Imagine you're having just a terrible day.
Oh, we've all been there.
Right. But, like, you're physically ill, your car mysteriously vanishes from your own apartment complex, and when you go down to the leasing office to figure out what happened, you get into a heated argument.
Which honestly sounds like a standard frustrating Tuesday for a lot of people.
Exactly. Standard Tuesday stuff.
Hmm.
But what if I told you that a 10-second, completely missing cell phone recording of that mundane argument would just completely destroy your life?
It sounds like a movie plot, really.
It does. But today, we are looking at a case where that exact nightmare actually became a reality. We're going to explore how a citizen can get systematically cornered by the very mechanisms designed to protect them.
Right. Cornered until their only way out is to stand up in open court and confess to something they didn't even do.
Yeah. So if you think you just, fight it out in court and that the truth would inevitably set you free, well, today's deep dive is going to seriously challenge that assumption.
It really is. Because today, the whole mission of this deep dive is to unpack a massive, highly detailed stack of legal documentation.
And it is a huge stack.
Oh, it's enormous. We are looking at sworn affidavits, actual court transcripts, body-worn camera narratives, FOIA requests, that's Freedom of Information Act requests, and visual exhibits.
There's a lot of ground to cover.
And all of this centers on the case of a man named Steven Todd Faircloth.
Okay, so let's unpack this. Our core focus today is forensically analyzing the total breakdown of the attorney-client relationship between Mr. Faircloth and his defense attorney, a guy named William Noland.
Yes, that relationship is key.
We are going to specifically zero in on a documented bait-and-switch tactic that led to a coerced guilty plea.
Which is fascinating and terrifying.
Right. We'll be looking at the mechanics of courtroom failures that seem to prioritize docket efficiency over actual constitutional due process, like just clearing cases off a list.
And before we get into the timeline, we really need to explicitly note a critical point about our source materials for everyone listening.
Yeah, that's important. Go ahead.
The documents, the transcripts, and the evidence we are examining today are presented from the defendant's perspective.
Right, from Faircloth's side.
Exactly. So our job here is not to take sides or to endorse the viewpoints contained within these documents. We are impartially reporting the facts, the transcripts, and the specific claims contained in the source material to understand exactly how the justice system operated in this specific instance.
We're basically just looking under the hood of the machine.
Exactly. Impartial analysis of the provided records.
Okay, so to understand why Steven Todd Faircloth ended up backed into an impossible corner in a courtroom, we first have to understand the inciting incident. Because this doesn't start with like a high-stakes bank robbery or a violent assault.
No, not at all.
It starts in a parking lot.
It starts at the Ansley Village Apartments. And the source exhibits paint a very clear picture of this complex.
What kind of place are we talking about?
Well, it's marketed to tenants as a secure, gated community. But the documentation, which includes tenant reviews and actual photographs, alleges that the gates were broken 95% of the time.
Which means anybody could just drive right in.
Precisely. And this wasn't just a minor inconvenience, It led to severe parking shortages.
Like people couldn't park where they lived.
Right. Actual paying tenants couldn't find a place to park their own cars at the homes they were actively renting.
Man, that is so frustrating. Now, I want you to put yourself right in Faircloth's shoes on the night this all really kicks off.
It's a rough night.
He is suffering from a severe case of salmonella poisoning. Now, if you've ever had food poisoning, you know the physical desperation involved.
Oh, it's awful. You can barely move.
The dehydration, the weakness, the sheer inability to function. So he couldn't physically manage to park hundreds of yards away on the other side of the complex and walk back to his apartment in the dark while violently ill.
Yeah, you just can't do it in that state.
So, in an emergency state, he parks near his unit, right in front of his own garage. And in his disoriented, sick state, he accidentally leaves his phone inside the car.
Which is a very normal mistake when you're that ill.
Right. And the next morning, he wakes up still feeling terrible, walks outside, and discovers his car is just gone.
gone, along with his phone.
Yes, his phone is inside it.
Mm-hmm.
It turns out it has been towed by the property manager, Heather Siebold, and Faircloth is now facing a $500 impound fee just to get his vehicle back.
And keep in mind, he rents a 2-bedroom unit. He's supposed to have 2 spaces.
Exactly. The gates are always broken, letting in non-residents, and yet he's the one targeted for a tow while he's sick.
It feels incredibly unfair.
So what does anyone do in that situation? He goes to the leasing office to demand answers. And this is where the entire trajectory of his life just completely shifts.
His documents describe a highly charged confrontation in that leasing office. Faircloth goes to confront the property manager about the tow. And during this heated exchange, Siebold pulls out her personal cell phone and starts recording him.
Okay, here's where it gets really interesting. The crux of this entire massive legal case, I mean, the arrests, the court dates, the jail time, the probation,
But all of it.
all of it rests on a single word, one phonetic sound captured on that phone.
Yes. Siebold and later the arresting officer, Deputy J.D. Johnson, claim that Faircloth said, quote, "I'm going to slap her?"
Gonna.
Right. And in the eyes of the law in that jurisdiction, that phrase is interpreted as a terroristic threat of imminent violence.
But Faircloth vehemently maintains, from the very first second and throughout years of legal battles, that he actually said, quote, "I want to slap her."
Wanna versus gonna.
Yeah. Now, to a casual listener, that might sound like a distinction without a difference, just semantics, right?
Sure, just splitting hairs.
But legally, it is everything. This is what the documents refer to as the linguistic pivot.
Great, let's break that down for everyone. Why does the law care so much about gonna versus wanna?
Because of intent and capability.
Yeah.
"I want to slap her" is legally characterized as a colloquial expression of intense frustration.
It's venting.
Exactly, it's venting. And under the First Amendment and established case law, venting frustration is protected speech.
Ah, I see.
It lacks the element of a true, imminent threat required for a terroristic threats charge. It means, "I am so angry I wish I could do this," not "I am actively about to do this."
Right, whereas "I'm gonna slap her" signals intent and imminent action.
Yes. The entire legal justification for his arrest hinges on that one consonant sound, the linguistic pivot.
It makes complete sense why that's the absolute center of gravity for his defense.
It has to be. But this brings us to a part of the source material that absolutely blew my mind. We have a document, FOIA request, SO 2024-544.
And for those who don't know, a FOIA is a Freedom of Information Act request.
Right. It is often a grueling bureaucratic process where citizens can demand government records. Faircloth had to fight just to get this piece of paper.
And what does it reveal?
This document reveals a shocking detail. Deputy Johnson arrested Faircloth based only on listening to Siebold's phone playing the audio out loud on speaker in the middle of a leasing office.
Wait, that is wild.
Yeah.
So the deputy listened to his cell phone speaker. He didn't take the phone into evidence.
Nope.
He didn't secure a copy of the digital file right at that moment.
Did not happen.
Huh?
The FOIA document explicitly states that Deputy Johnson advised that Missy Siebold was, quote, "never able to successfully send the videos or audio to him."
You're kidding.
No. And he supposedly reached out to her again later to try and get them, and she advised she, quote, no longer had the videos or audio.
Let me stop you right there. How is that even possible?
I know, right?
I mean, I can airdrop a 4K video to a stranger across a coffee shop in 3 seconds.
Literally 3 seconds.
But a police officer investigating a felony threat can't figure out how to get an audio file from a property manager. And then the complainant just, loses it.
Just loses it. It raises profound questions about police procedure.
Oh, absolutely. In investigative terms, this is referred to as a catastrophic failure to independently verify.
It's like getting a speeding ticket because a police officer looked at a civilian's blurry Polaroid of a radar gun.
That's a great analogy.
And then the civilian just throws the Polaroid away and the cop says, "Well, trust me, I saw the Polaroid." How does an arrest hold up without independent verification or preserving the primary evidence?
It really shouldn't. If we connect this to the bigger picture, it highlights how law enforcement in this instance relied entirely on a complainant's unpreserved, unverified narrative.
They just took her word for it?
They completely ignored the statutory gap between a frustrated utterance, the wanna, and a true intent to terrorize the gonna. The officer basically adopted the property manager's framing of the event without securing the actual digital proof to back it up.
And because that arrest was based on ghost evidence, what happened next at the jail wasn't standard processing.
No, it wasn't.
It was a sequence of events that the documents describe as deeply traumatizing for Faircloth. And this is crucial because this trauma isn't just an unfortunate side effect.
Right.
It creates the psychological leverage that the system uses against him later.
Because an arrest isn't just paperwork, you
Yeah.
know? It is a physical, forceful deprivation of liberty.
It's violent, yeah.
And the circumstances surrounding Faircloth's booking raise serious red flags in the source material regarding coordinated retaliation.
Yeah, the host of documents point to an environment that feels incredibly insular and punitive. Let's look at the summaries of the body-worn camera footage.
Okay.
After the arrest is made, Deputy Johnson is captured on his own body cam, telling the property manager, "Seabolt, you're welcome."
Wow.
And Seabolt replies, "I owe you one."
I owe you one. That exchange is incredibly revealing.
It really is.
It strongly suggests that this arrest wasn't just a neutral, objective application of the law. It paints a picture of a personal, prearranged favor, a transaction between a civilian and law enforcement.
And the context makes it even worse. The exhibits show that Seabolt boasts about her family ties to the sheriff's office.
Oh, of course.
Her father is a retired investigator. Her stepbrother is a current deputy in that very department.
So she has deep connections.
Deep connections. And according to the analysis of body cam footage, that specific stepbrother is allegedly seen exiting the booking area right as Faircloth is being brought in handcuffs.
Just casually walking out.
Yeah. The documents even note a fist bump between Deputy Johnson and an individual at booking.
So the documents frame this as a coordinated effort to ensure Faircloth received particularly harsh treatment. It's a weaponization of local relationships.
And that harsh treatment is meticulously documented. Once Faircloth is in the system, he isn't just processed, fingerprinted, and placed in a standard holding environment to wait for a judge.
Which is what should happen.
Right. But no, he is placed in holding cell number 4. And he is left there for 13 hours.
13 hours for a disputed misdemeanor threat charge.
Yeah.
Tell me that isn't standard operating procedure.
It is absolutely not standard. Let's look at the conditions of that hold. 13 hours. Without a toilet. Without food. Without water. Without a phone call.
That is horrifying.
He is completely isolated and deprived of basic human necessities. And remember, he was suffering from salmonella poisoning just hours prior.
Dehydration from salmonella is no joke. Being locked in a room with no water or toilet in that condition is legitimately dangerous.
It's a major health risk.
And to add insult to absolute injury, during this period of extreme vulnerability, his great-uncle's gold ring, a family heirloom, is stolen.
Unbelievable.
The documents note it was left on a coffee table during a later related incident, which ties into a broader pattern of property vanishing under the color of law that he experienced with this department.
Right. Things just go missing.
But focusing on the jail holding 13 hours without a toilet, we really have to pause and consider the psychological impact of that environment.
It's torture.
This isn't just about an uncomfortable night sleeping on a concrete bench. This is sensory and physical deprivation. This is custodial abuse. When you deprive a human being of the ability to use a restroom or drink water, you are breaking down their fundamental sense of agency.
Put yourself in Faircloth's shoes for a second. You were sick. Your car got towed from your own home where you pay rent.
Right.
You went to complain. You were recorded. The audio mysteriously vanished. The cop arrested you based on a ghost of a recording.
Just a sequence of nightmares.
And then you are thrown into a concrete box for 13 hours without water while the property manager's family allegedly watches from the hallways, fist-bumping the arresting officer. You aren't just confused at this point.
No, you are completely terrified of the system.
And that terror is the point.
Yes, exactly.
What's fascinating here is how this custodial abuse functions as long-term psychological leverage. It sets the stage for what the documents call a plea under duress.
The fear of returning to those inhumane conditions at the Bibb County Jail becomes this invisible, crushing weight.
It's always there in the background.
Right. It presses down on Faircloth throughout the entire rest of the timeline. The system has shown him its teeth. He knows what happens behind closed doors, and he knows they can put him back in that box whenever they want.
The system has established absolute dominance. So hold that feeling of terror in your mind, because we are going to fast forward 17 months.
Almost a year and a half.
We are out of the jail cell, but we are deep into the machinery of the court. Faircloth is out on bond, but he is facing trial.
Okay.
He knows the audio is disputed. He knows the original clip is missing. He wants to fight. He knows about the linguistic pivot.
He knows he's right.
But the system has a totally different priority.
We are looking at transcripts from a pretrial hearing on December 15th, 2023. This is before Judge Cheryl Lewis.
Right. And right out of the gate, Judge Lewis notes on the record that this is the oldest case on the docket.
Ah.
This is the 6th time this case has been on the trial calendar. The court just wants this gone.
This raises an important question about how courts actually function. We like to imagine courts as these pristine laboratories of justice where every case gets infinite time and attention.
Like in the movies.
Exactly. But the reality is that courts are administrative processing centers. They are incredibly backlogged. Judges are evaluated on their docket efficiency, how quickly they can move cases through the pipeline.
It's an assembly line.
Yes. An old case that has been on the calendar 6 times is an administrative headache. The pressure to resolve it by any means necessary is immense.
And Faircloth steps up to the podium into that pressure cooker, and he wants to do something very specific. He wants to fire his defense attorney, William Noland.
And why is that?
Because according to Faircloth's affidavit, Noland has completely dismissed his claims about the altered or missing audio. Noland has literally called Faircloth delusional for wanting to build a defense around the linguistic pivot and the missing original file.
Imagine trusting your freedom to a professional advocate, and that advocate calls you delusional for pointing out that the state's primary piece of evidence doesn't actually exist.
It's mind-boggling. So Faircloth tells the judge he wants a new lawyer. And Judge Lewis shuts him down with breathtaking speed. Let's look at the transcript.
What does she say?
Faircloth tries to bring up the evidence. He says, quote, "The video, the audio, it was altered."
Okay, he's trying to make his case.
And Judge Lewis responds, quote, "All right, Mr. Faircloth, one more word about the evidence in this case, and you will go to jail for contempt. Do you understand me, yes or no?"
Wow. She threatens a man with jail time simply for attempting to assert his core defense in a pre-trial setting.
Yeah.
She tells him, "You're not going to get into the facts of the case. That's not what we're here for today."
She threatens him with the very thing he is terrified of, going back to that jail. The judge tells him his case will be tried in 2 weeks.
That's a tight deadline.
She explicitly tells him, quote, "You may find a lawyer that will take your case. What you're not going to find a lawyer to do is take your case and say, oh, we've got 2 cases that are as old as yours that are ready. And you have one of the best criminal defense attorneys in 5th County."
Unbelievable.
She praises the lawyer who just called the client delusional, warns him that no one else will take the case on short notice, and then delivers a severe warning about representing himself.
Yes, the warning against proceeding pro se. For our listeners, pro se is a Latin term meaning for oneself. It means acting as your own lawyer.
Wait, why is the judge acting like that's an automatic death sentence for his case?
Yeah.
People have the constitutional right to represent themselves, don't they?
They do, but the legal system makes it incredibly perilous. Judge Lewis states on the record, quote, "Because it is not an appealable issue that someone who represents themselves at a jury trial is convicted because a person representing them was wholly and completely unprepared to do that."
I get it.
What she is saying is, if you act as your own lawyer and you don't know the complex rules of evidence, like how to properly introduce the FOIA request or how to question a witness, and you lose, you cannot appeal your conviction by claiming you had incompetent counsel.
Because you were the counsel.
Exactly. She is legally boxing him in.
It's an illusion of choice. It's like your accountant telling you the IRS is auditing you, and your accountant thinks you're crazy for wanting to show the IRS your actual receipts.
Right.
So you try to fire the accountant, and the IRS auditor looks at you and says, listen, this is the best accountant in town. If you try to do the audit yourself without an accountant, we will fine you into oblivion, and you can't appeal it.
So sit down and let him handle it.
Exactly. You are completely defenseless.
That analogy captures the coercion perfectly. This transcript is a masterclass in judicial pressure. If we examine the mechanics of this, we see a glaring systemic issue here.
Okay.
Efficiency versus due process. Judge Lewis tells Faircloth that to challenge the audio in court, he requires a proper evidentiary foundation.
What does that actually mean in plain English?
It means you can't just stand up in front of a jury and say, hey, the audio is fake. You need an expert witness, a forensic audio analyst, to testify under oath about the metadata, the frequency, the missing files.
Makes sense.
But here is the catch-22. Faircloth's attorney, William Noland, the one the judge is forcing him to keep, hasn't hired an expert.
Oh, man.
So the system uses its own complex procedural rules to essentially mandate a guilty plea. The judge demands a standard of evidence that she knows his current court-mandated lawyer refuses to provide.
It's a closed loop, a bureaucratic trap.
Truly.
So faced with a judge threatening contempt, threatening jail, demanding an expert he doesn't have, and refusing to let him find a lawyer who will get that expert.
Yeah.
Faircloth is forced out of the courtroom and into a hallway conversation with William Noland, the very lawyer he just tried to fire.
And this brings us to one of the most highly specific and deeply troubling parts of the documentation from an ethical standpoint.
Yes, the hallway conversation.
We have access to the newly transcribed audio of the conversation between Faircloth and Noland immediately following the judge's ultimatum in that hallway.
And in this hallway conversation, Noland's tune suddenly changes.
Does it?
Yeah. He's just been backed by the judge, but he knows his client is furious. He acknowledges that they have a, quote, fundamental disagreement about the audio. But crucially, to keep Faircloth from going back into the courtroom and insisting on firing him and going pro se, Noland admits there are valid legal ways to challenge the missing evidence.
Interesting.
He tells Faircloth the exact strategy they could use in front of a jury.
Right. Noland outlines what is legally known as a best evidence defense.
Explain the best evidence rule for us. Why is that so important here?
The best evidence rule is a legal doctrine that essentially says, to prove the content of a recording, photograph, or document, the original must be produced in court. You can't just have someone testify, I saw a document that said X, if the document itself is available. In this case, Noland says, and I quote from the transcript, we can ask, where's the original audio? Why don't we have her phone? And argue, this is not the best evidence.
He's handing him the playbook?
He explicitly maps out the very defense that Faircloth has been begging for. He validates the legal strategy.
He validates it, and then he makes the promise. This is the bait.
The bait.
Noland tells Faircloth, quote, I'll immediately get to find us an audio expert. He promises to get a forensic audio professional to look at the files.
Okay, that sounds promising.
He also promises to finally upload the police body-worn camera footage to a Dropbox or put it on a thumb drive so Faircloth can actually finally see the evidence against him.
And this is the pivot point of the entire attorney-client relationship. Based entirely on these representations, the explicit promise that Noland will finally investigate the missing evidence, hire an audio expert, and provide the discovery files, Faircloth agrees to retain Noland.
He falls for it.
He goes back into the courtroom, compliant, believing his lawyer has seen the light and is finally going to fight for him.
I have to ask a critical question here, and I want you, the listener, to really think about this. Why would an attorney articulate the exact, correct legal strategy to challenge missing evidence?
Right.
Promise a client he will hire an expert to execute that strategy.
Right.
And then just not do it.
It's a huge question.
Is this basic incompetence? Or is this a calculated move to keep a difficult client compliant so the case can just be pled out and closed?
This touches on the fundamental mechanics of legal representation. Attorneys have a professional duty of candor.
Meaning they can't lie to their clients.
Exactly. Promising a specific investigative action, especially hiring an expert witness to retain a client who is under severe judicial pressure, creates a binding professional expectation.
You can't just make things up to calm them down.
No. An attorney cannot make a material promise about defense strategy merely to pacify a client and satisfy a judge's desire to keep the calendar moving. If the attorney had no intention or ability to hire that expert, making that promise is the definition of the bait in a bait and switch.
Manipulative.
It manipulates the client's consent to representation. It is using the client's desperation against them.
It's essentially fraud within the attorney-client relationship. Faircloth bought a defense strategy that was never going to be delivered. He bought a phantom expert.
So Faircloth goes home. He waits.
And waits.
He waits for the Dropbox link containing the body cam footage. He waits for the name of the audio expert. He waits for the forensic analysis that will finally prove the wanna versus gonna linguistic pivot.
But January 2024 rolls around. It is plea day. And what actually happens? Absolutely nothing.
Nothing at all.
No audio expert was ever retained. No forensic analysis was ever performed. No motion was ever filed to obtain the original source recordings or Seabolt's phone based on the best evidence rule.
It's stunning.
Faircloth never even received a copy of his own body cam footage to review. Nothing Noland promised in that hallway happened. Zero.
This is the switch. The promised defense has completely vanished. Noland's strategy shifts entirely away from the best evidence attack he mapped out in the hallway and pivots to pure, unadulterated pressure.
How does a lawyer physically pivot their advice like that? How do they look a client in the eye after promising an expert?
They rely on the sheer weight of the impending trial. The transcripts show Noland telling Faircloth right before the plea, quote, "Well, they'd have convicted you anyway, even for what you admit to saying, probably."
What a betrayal.
He completely abandons the defense strategy he himself validated and adopts the prosecution's narrative of inevitability. He tells the client the ship is sinking and the only life vest is a guilty plea.
And this creates the ultimate emotional climax and legal trap for the defendant. Let's look at the parameters of the trap Faircloth is now caught in.
It's a tight spot.
He is facing consecutive 12-month sentences if he loses at trial. He is facing a judge who has already threatened him with jail for contempt just for speaking about his defense. And he is standing next to a lawyer who has completely abandoned the agreed-upon strategy.
He is totally isolated. The system has ground him into dust.
And so, on the record, during the plea hearing, we hear one of the most tragic admissions a defendant can make.
It's hard to read.
Faircloth says to his attorney, caught on the audio, quote, "I'm not kidding you. I didn't say what Heather had on that recording. I swear to God on all my life, and it makes me mad that I have to admit to it. Something I didn't do."
Something I didn't do. And yet he signs the plea.
So what does this all mean? Let's look at the tragic irony of this entire machine. The court demanded that Faircloth have a proper evidentiary foundation and expert to challenge the missing audio.
Yes.
Faircloth's lawyer explicitly promised to hire that expert and build that foundation.
The lawyer didn't do it.
He failed to deliver. And then on plea day, the lawyer used the lack of that foundation, the lack of that expert, to convince the client that a trial was hopeless and he had to plead guilty. It's a perfectly sealed trap. The lawyer manufactured the hopelessness that he then used to extract the plea.
What you were describing is the anatomy of a coerced plea. When we hear coerced, we often think of rubber hoses or physical violence in an interrogation room.
Right, like old movie stuff.
But this case demonstrates a modern, bureaucratic coercion. It wasn't coerced by physical force. It was coerced by the systemic dismantling of the defendant's ability to fight back.
Psychological.
And the most heartbreaking part is that this dismantling was orchestrated by the very person hired to defend him, facilitated by a judge prioritizing the docket over truth. The system leverages its own procedural rules to crush the presumption of innocence.
It's terrifying. You just sign the paper to make the threat of that 13-hour cell go away. You think, I'll just take the hit, take the probation, and get on with my life. Because a plea deal might seem like the end of the story, right? You sign the paper, you pay the fine, you go home.
That is a very common misconception. In a system built on leverage, a plea deal is often just the beginning of a new kind of captivity.
A new captivity.
Yes. The criminal justice system doesn't always want to put you in prison. Often, it just wants you on a leash. Let's look at the actual sentences Faircloth received from this coerced plea.
He pleads guilty to battery and criminal trespass. He receives 12 months of probation, mandatory anger management, and crucially, a mandatory mental health evaluation.
Now, on the surface, to a casual observer, probation and a mental health evaluation might sound progressive or lenient. It sounds like rehabilitation.
Sure, it sounds helpful.
But we need to break down the bureaucratic mechanics of what the source material identifies as the probation hook.
The probation hook. Explain how that works in this context. How does a mental health evaluation become a weapon?
When you are on probation, your liberty is entirely conditional. You are essentially serving a jail sentence in the community, subject to strict rules. If you fail to meet a condition, your probation officer can file a violation.
Okay, that makes sense.
Let's take the mandated mental health evaluation. A court orders an evaluation. The evaluator, often a contracted third party, makes a subjective assessment. If you dispute their findings, perhaps they misunderstand the facts of your case or mischaracterize your frustration over a towed car as pathology, your dispute is framed by the probation officer as noncompliance.
So if you argue with the evaluator, you are violating probation.
Exactly. Or say you miss an anger management class because your car was towed or you couldn't get off work. That is a technical violation. You aren't fighting the original charge anymore. You don't get a jury trial for a probation violation.
You're just at their mercy.
You are fighting the probation officer in front of a judge who already assumes you are guilty. The documents show that this initial legally dubious plea directly facilitated a later devastating 72-day detention for Faircloth based on these very conditions.
72 days.
He was locked up for over 2 months, not for a new crime, but for the mechanics of probation.
Think about that. You might think, well, I just take the probation to make the trial go away. I'll jump through the hoops. But this case shows that probation isn't freedom. It's a leash.
A very short leash.
And if that leash was attached to your neck using a bait-and-switch tactic based on missing evidence and a phantom expert, you are entirely at the mercy of a broken system. You have handed them the remote control to your life. A single missed appointment or a subjective evaluation can throw you right back into that cell.
And if we look at the broader systemic toll, the entire Annesley Village narrative is a profound warning. We go from a towed car while a man has salmonella,
To an unverified, distorted 11-second audio clip that the police lose.
to an officer arresting without preserving that evidence,
To a 13-hour abusive holding cell.
to a judge threatening contempt,
To a defense attorney promising a phantom expert to secure a client's compliance.
to a coerced guilty plea,
To weaponized probation.
and finally to a 72-day detention.
It is a staggering sequence of events.
It really is. It shows how structural inefficiencies, judicial impatience, and attorney negligence don't just exist in a vacuum, they compound.
They build on each other.
They stack on top of each other, utterly destroying a citizen's life under the guise of official business.
A cascade of failures.
Ah.
So let's bring this all together. We started this deep dive, asking you to imagine being trapped in a bureaucratic nightmare, falsely accused based on missing audio, with a lawyer who thinks you're crazy and a judge threatening you with jail.
Right?
We've seen exactly how that nightmare became a reality for Steven Todd Faircloth. A man lost his presumption of innocence the exact moment a civilian's unverified audio clip was accepted as gospel by law enforcement without proof.
Without any proof.
And his constitutional right to a fair trial vanished the moment his own defense attorney broke a fundamental promise to investigate that evidence.
It is a stark reminder that the justice system is comprised of people, and when those people prioritize process over truth, the individual is always the one who pays the price. The machine keeps running, but the human being is crushed in the gears.
Always. And as we wrap up, we want to leave you with a final, chilling thought, something to mull over the next time you look at the device in your hand.
We live in an era where everyone has a high-definition recording device in their pocket. We capture everything. But if the justice system allows secondary, easily manipulated digital files that the police don't even bother to collect to result in an immediate arrest, and if courts prioritize clearing their dockets over forcing the production of those original source devices, are any of us actually safe from a maliciously edited 10-second soundbite?
That is the big question. Thank you for joining us on this deep dive. Until next time, always question the best evidence in your own life.